Major breaking news out of the United States Supreme Court in the case of Gray versus Jennings, the final legal brief to be filed by the parties before the U.S. Supreme Court will decide whether or not to grant cert in this Delaware assault weapon magazine ban case has just been filed. Therefore, the issue has been joined. The U.S. Supreme Court is now in a position to decide which, if any, of the 3 AR-15 magazine ban cases before them they're going to decide this term. Let's talk about this brief that was just filed in Gray versus Jennings and what are the next steps. Here we go, folks. All will be decided in the next several weeks, and Gray versus Jennings will be one of them. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the new law review article in the Georgetown Journal of Law and Public Policy. A free copy below, 65 pages of scholarship and legal arguments and history and the like about our Second Amendment rights. The title of the article is Dangerous But Not Unusual. Check it out. If you're interested in the Second Amendment, you're going to definitely want to read this article. A link in the description of this video. All right, folks, so as you know, there are 3 cases before the U.S. Supreme Court touching fingers with the issue of gun bans, specifically AR-15 bans, semi-automatic rifle bans, large capacity magazine bans, which of course are just standard capacity magazine bans. And this case we're about to talk about, Gray versus Jennings, out of the state of Delaware, which deals with the standards when a court can enjoin, which means to stop, to freeze, if you will, the enforcement of a modern-day gun control law that violates our Second Amendment rights. Now, this is the last brief to be filed by the parties, either in support of the Second Amendment or against the Second Amendment in those 3 cases. Gray versus Jennings out of Delaware, dealing with the assault weapon ban there, the magazine ban there. Ocean State Tactical out of Rhode Island, dealing with the large capacity magazine ban there in Rhode Island. And of course, Snope versus Brown, the AR-15 semi-automatic rifle ban out of the state of Maryland and the U.S. Court of Appeals for the Fourth Circuit. Those are the 3 cases. In a perfect world, I think we want the Supreme Court to grant cert in all 3 of those cases. But most importantly, we definitely want them to grant cert, in my opinion, in Snope versus Brown to resolve once and for all the question of whether or not modern governments can ban semi-automatic rifles, including the AK-47 and the AR-15. The answer to this question is really very easy. They cannot do it. As long as the Supreme Court applies its Heller precedent, it's game over for the anti-gunners. We just need the U.S. Supreme Court to have the fortitude, the courage to step up and do the right thing, to defend their precedents, to defend the Second Amendment, and to treat it as a first-class right and not a second-class right, and do what needs to be done, and to take the opinion that then Judge Kavanaugh, when he was on the D.C. Circuit, wrote in the Heller 2 case, as in dissent, saying why D.C.'s ban on semi-automatic rifles was unconstitutional under Heller. So with that said, the last step in this process, prior to the Supreme Court deciding which case they're going to take, if any, has just occurred. And that is the last reply brief has been filed by the Second Amendment plaintiffs in the case of Gray versus Jennings. They're asking the court to grant cert. And as you know, grant cert means that the Supreme Court will grant cert, which means they will hear the case on the merits. They only hear about 70 cases a year on the merits, and they turn down thousands and thousands and thousands of petitions for cert all across this country. And again, there's 3 Second Amendment cases that we care about pending, meaning their petitions for cert are pending. And we're waiting to hear if the Supreme Court's going to grant cert in 1 or more of these 3 cases. Now, this Gray versus Jennings case deals with the gun ban case, or gun ban law out of Delaware. But what makes Gray versus Jennings unique is it's arguing that the reason why the Supreme Court should hear this case is because the standards that the lower courts applied in deciding whether or not to enjoin, which means to stop or freeze, the Delaware gun control law was misapplied. Specifically, the question is, in this case, whether or not once a court finds that the government's law violates the right to keep and bear arms in the Second Amendment, is that the only thing that has to occur before a court enters an injunction. And by extension, the question in this case is whether or not merely finding that it is likely the case that the modern-day gun control law violates the Second Amendment right of an individual, does that mean by definition and automatically an irreparable harm has been suffered or has occurred to injure, if you will, the Second Amendment plaintiffs? And that's the question, because the lower court, the U.S. Court of Appeals for the Third Circuit out of Delaware, New Jersey, and Pennsylvania, 3-judge panel, said that a Second Amendment plaintiff, in order to get an injunction, has to show a lot more than just they're likely to win on the Second Amendment claim. They also have to show irreparable harm, a balance of the equities, and it's in the public interest to enjoin the government conduct. Now, there is a circuit split here. The Ninth Circuit and the Seventh Circuit have basically said that once the Second Amendment plaintiffs establishes there's a violation of the Second Amendment, a preliminary injunction or ultimately a permanent injunction should issue. The Third Circuit Court of Appeals said that's not the case. The Second Amendment plaintiffs have a lot more to show than merely there's a likely violation of the Second Amendment by that gun control law. So in this back and forth, the Second Amendment lawyers, on behalf of Gabriel Gray and the other plaintiffs against Kathy Jennings, the Attorney General of Delaware, point out exactly that it is indeed the case that once the Second Amendment is violated, an injunction should issue. Here's what they argue in their brief, this reply brief, the last step in the path for the Supreme Court to decide whether or not to hear this case. This is what they argue. This Supreme Court has held that the loss of First Amendment freedoms unquestionably constitutes irreparable injury due to their intangible and unquantifiable nature, but it has not yet explained the principle at length or decided whether it applies to other intangible constitutional rights, such as those protected under the Second Amendment. This lack of guidance has led to confusion in the lower courts, and now a split between the Seventh and Ninth Circuits on the one hand, which hold that infringements to the Second Amendment right cannot be compensated by damages, and the panel below in the Third Circuit on the other hand, which respectfully declined to follow their sister circuits and instead held that the violation of petitioner's Second Amendment rights did not constitute or cause irreparable harm. So that's the essence of the argument why the Supreme Court should grant cert and find that the Second Amendment is a fundamental right, it is not a second-class right, and should be treated on par with like the First Amendment's right to free speech, the First Amendment's religious clauses, which means that as soon as it's established that a law likely violates the Constitution, likely violates the Second Amendment here, then a preliminary injunction should immediately be entered enjoining, which means stopping a government from enforcing that law against American citizens. And what's interesting here for you people out there in the left coast, California and Washington, out there under the yoke of the U.S. Court of Appeals for the Ninth Circuit, it turns out that the Ninth Circuit actually is pretty good on this issue in favor of the Second Amendment. You heard me right. Here's what this brief says actually about why the Ninth Circuit is actually good on the Second Amendment with respect to this question of the standards for a preliminary injunction in a constitutional fight, including a fight over your Second Amendment rights. Here's what they argue. The Ninth Circuit in Baird could not have more clearly endorsed the same rule as Ezell. It held that the deprivation of constitutional rights unquestionably constitutes irreparable injury, that no further showing of irreparable injury is necessary, and thus that if a plaintiff bringing such a claim shows he is likely to prevail on the merits, that showing will almost always demonstrate he is suffering irreparable harm as well. Powerful language by the U.S. Court of Appeals for the Ninth Circuit in support of the Second Amendment. And it's great that they reminded this of the U.S. Supreme Court to say, how is it possible that the Ninth Circuit is actually good on this issue involving the Second Amendment, and this Third Circuit panel screwed this up. And that, of course, is because the argument is that once there's a violation of the Second Amendment, it is a per se irreparable harm, irreparable injury to the Second Amendment plaintiffs. This is what they go on to argue based on that notion. We do insist on this point. In the ordinary case where a constitutional infringement is not monetary in nature, the lower courts are clearly in turmoil over which constitutional rights are incapable of being redressed at law. What types of violations of those rights lead to per se harm, and why the irreparable harm factor is satisfied in these cases. Now, to understand this Gray versus Jennings case, if you want to get a little geeky here, is this. The government of Delaware is trying to say that the Second Amendment plaintiffs are trying to create a special loophole, if you will, for Second Amendment claims. To say that, look, in any other context, this is what Delaware argues, in any other context, a plaintiff seeking to get an injunction by a court to stop some conduct has to satisfy 4 elements. They have to show that they're likely to prevail on the merits of the claim. There's irreparable harm there, which means as a general matter, it cannot be established that there's monetary damages, or that monetary damages cannot be readily ascertained. That when you balance the equities of the good and the bad of entering an injunction, the balance of the equities are in favor of issuing the injunction in favor of the plaintiff, and that it's in the public interest, meaning it's not going to do something that's going to harm the public. Those are the 4 elements. Now, the reality is this. If you're dealing with a commercial fight over a patent, copyright, trademark, some sort of breach of contract, any of these kinds of things, anything associated, let's say, with non-compete agreements, then these 4 elements are all very important to fight them all out. But when you're dealing with a constitutional right found in the Bill of Rights, whether it be the First Amendment or the Second Amendment, for example, the mere fact that the right is being infringed by modern-day gun control law, let's say, or modern-day law at all, means that law should be enjoined. Because if you think about it, there's 4 elements to an injunction before it issues that you have to satisfy. The first is your likelihood of success. So if you're able to show that you're likely to win that a modern-day gun control law violates the Second Amendment, or you're likely going to win that a modern-day law violates, let's say, the First Amendment right to religious freedom, or a modern-day law shows is likely that modern-day law likely violates your First Amendment right to free speech, for example, the first element of likelihood to succeed on the merits of your claim has been satisfied. So now you only have to satisfy the other 3. But once you've shown that your constitutional rights are being violated, the other 3 should naturally flow automatically. Because the irreparable harm is, again, it's often very difficult to show the consequence of not being able to, let's say, go to church. What are your monetary damages from if I ban you from going to Mass, let's say, if you're a Catholic? What are your damages? How can I show you? How can I establish your damages from denying you the ability to go to church, to go to Mass, right, once a week for the next 18 months? It's not that easy, right? It's not clear. Maybe there's some theoretical ways of doing it, but as a general matter, it's not obvious that that's doable in any real way. Of course, also the balance of the equities. Well, government has no interest in the enforcement of unconstitutional law. So when you balance the equities of the good and the bad of enforcing unconstitutional law, it really only goes one way, which is you should enjoin it, because, again, there is no interest on the part of government to enforce a law that's unconstitutional. And last but not least, what's in the public interest? Well, the public, again, has no interest in the enforcement of an unconstitutional law. So once you really establish in the context of the First Amendment or the Second Amendment that the claim against that law is likely violative of the First Amendment or the Second Amendment or the Constitution, the other elements that you usually have to satisfy for a preliminary injunction are automatically satisfied. It's a little bit different if you're dealing with a commercial dispute, which I'm quite familiar with. But again, this is not a commercial dispute. This involves fundamental constitutional rights. So the dynamic in the approach to these 4 elements is much different, in my view, than if you're dealing with a breach of contract, landlord-tenant issue, any of these kinds of issues that you might see in the commercial space fighting over money, let's say. So again, the question that the Supreme Court has to decide is this argument that you only have to show the one element that there's a likely violation of the Second Amendment. Is that enough to establish that an injunction should issue? Is that just basic constitutional law? Or is it the Delaware view that creates a loophole? Now, according to the Second Amendment plaintiffs, there is no loophole. It's just treating the Second Amendment on par with the rest of the Constitution. This is what they write. Their argumentation on this score is fatally flawed because it is based on the same misconception of the Second Amendment petitioner's position as adopted by the panel majority, that petitioners, meaning the Second Amendment supporters, are somehow attempting to create a loophole in the preliminary injunction standard for the Second Amendment. But this is false. The Second Amendment petitioners do not claim that Second Amendment plaintiffs are not required to make a showing of irreparable harm. The Second Amendment petitioners' argument is that the violation of intangible Second Amendment rights constitutes in and of itself irreparable harm. All right, folks, so that's it. Gray versus Jennings is now fully briefed. We're going to find out if they're going to distribute this case to the justices for conference within the next week or so. We'll find out what's going on, and as soon as I hear, I will report to you, because this is it. You know, the next month is what's going to make or break us on this AR-15 ban case. If we don't get the court to grant cert in one of these three cases, we're not going to be in good shape. I'm not saying we're in catastrophic shape or we're terrible shape, but I don't think that's a good sign, because it's going to be a signal to me that the Supreme Court doesn't have the fortitude to step up and do the right thing. If they do grant cert in these cases, I'm going to take that as an extremely good sign. But, you know, only time will tell. So I'm keeping my candles lit, my fingers crossed, my toes crossed. I'm saying my prayers at night to say we need the Supreme Court, and please, Supreme Court, take one of these cases, if not all three. That's where I'm at right now, and that's where you should be at as well. So, you know, let's see what happens over the next 3 to 4 weeks. Let's hope it all works out. I'm cautiously optimistic, but I don't control the Supreme Court, so anything's possible. So there you have it, folks. Hope you learned something today and enjoyed it. Make sure you follow me on X @ForBoxes Diner. Don't forget to check me out on Rumble if you have a Rumble account, because I'm now posting these videos on Rumble as well as YouTube. And make sure you subscribe to this channel and share it with your friends. And I look forward to talking to all of you again very, very soon here at the Four Boxes Diner.
Orders up. Table 2A.